Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching if you're catching this on YouTube, and thank you for listening for those that are listening to this on Apple or Spotify podcasts. The Mass Casualty Commission hearings are being delayed until late January, early February, as discussed here before, but that hasn't stopped some news from coming out. In fact, this week there was some news regarding non-disclosure agreements and also about possible compensation offers that are being made to family members of some of the victims from the mass shooting. So I wanted to talk to you a little bit about that, about those two topics, and just give you some updates on what that might mean for the upcoming Mass Casualty Commission inquiry hearings. So these revelations this week came out through Paul Palango and Jordan Bonaparte. Paul Palango is a journalist. He's writing now for Frank magazine, has written before on this story for the National Post and Maclean's. Longtime journalist, knows the RCMP well, very credible, has great sources inside the RCMP and otherwise. And from what people in the area have told me, his work is quite accurate, so I've been following his reports all throughout. And Jordan Bonaparte has a podcast where Mr. Palango is a frequent guest, and he's got about 6,000 YouTube subscribers. A very good quality podcast, so I would encourage people to check that out. It's the Nighttime podcast. These two have been very valuable actually throughout this for getting information out to the public that the RCMP has either seemingly tried to conceal or just not wanted to get out there. So it's been very, very helpful for everybody in the public, and myself included. So the two things, as I said, were non-disclosure agreements and compensation offers. The non-disclosure agreements, and they posted a copy which purports to be a version of one of these. Now, a non-disclosure agreement means just what it says, that you are given confidential information and you're not allowed to disclose it. And what the suggestion is here is that these, as the families and their lawyers are going through meetings currently over a course of 5 weeks to prepare what are called foundational documents, factual accounts, agreed statement of facts of what's taken place prior to the hearings, that they're being told that they need to sign these non-disclosure agreements so that any information that they receive, that are privy to, that is not included in the foundational documents, that they would be precluded from ever disclosing this in any form. And of course that's problematic, because if there's information outside of the foundational documents, the only way us as members of the public are going to see it is if family members, other parties to the inquiry, are able to cross-examine witnesses, bring up some of this information. So if in fact these non-disclosure agreements are meant to be permanent, then this could be quite problematic, and I think would need to be something that the commissioners will have to address. My sense is that the non-disclosure agreements have a temporary effect, although I will say the document that was posted didn't indicate anything to that effect. It didn't say anything about a temporal limitation. And in fact, the Mass Casualty Commission has issued a statement, a tweet, in fact, that denied that they were using non-disclosure agreements, but suggested that instead they were using confidentiality agreements. Now, that's what we would call in law a distinction without a difference. Confidentiality, non-disclosure, effectively the same thing. So we'll see how that develops. The other issue that, and I'll come back to that, the other issue that came up was that there's possibly compensation offers, sizable compensation offers, being made to families of the victims of the shooting. Now, I would have thought that any compensation offers would have been limited to those victims, post Portapique, the portion after the night of the 18th. So if it's earlier, in fact, so if the victims in Portapique proper are being compensated, that tells us that the RCMP must feel that there is something beyond, in other words, preceding the incident itself, which would be drawing civil liability. And one would have thought the victims outside of Portapique might be compensated because, the RCMP is at fault for allowing the gunman to escape, not calling in helicopters, not calling in an emergency alert to let people know that there was an active shooter on the loose. But if there's something in the Portapique proper situation that's drawing civil liability, and the RCMP is prepared to admit that, that is significant. I can tell you as somebody that has carried litigation against the RCMP on a number of occasions that their tactics are usually to deny and blame others, including victims in some cases. So that is a significant thing to watch. The other issue with compensation is this. Think of this from the lawyer's perspective. Lawyers, in this case, are representing the victims' families in both the civil litigation side, there's a class action underway, and also through the Mass Casualty Commission. Now, when you're representing clients, you have to think of their best interests, and the best interests of the families, in this case, those most affected, may be limited to privately conveyed information and compensation. It may matter comparatively little to them whether some of this information becomes public, and in fact there may be details about family members, possible connections with the shooter that they may find embarrassing or may wish to keep private themselves. So the public interest is the complete opposite of that. We would want the most details made public, with few limitations. So compare that. So there's a conflict there in the motivations, or the potential motivations. If this compensation offer story is accurate, compare that now to the Desmond inquiry, where compensation was not mixed in, and the family representatives were able to focus exclusively and entirely on the public interest, and they became a proxy of sorts for the citizens versus the government in that situation. So here, if the Mass Casualty Commission is only going to have government representatives and somewhat neutered family representatives, then the public is going to be shortchanged, and that's a problem. Then it would be just the commissioners themselves, the three commissioners, who would have the explicit mandate to think of the public interest. So it's not a promising scenario. You have a few things. We have an overwhelming volume of material to go through. There's time pressure on the commissioners to report and to show some results. They have to issue a final report by next November. And so it would be easy to occupy a lot of that time with less controversial content. So we'll see how that develops. So those are two things, if accurate, and no reason to think at this point that they are not accurate, that gives us some concern, and so it means we should watch closely, and I'll certainly be watching closely in the early cross-examinations of witnesses for signs that we're going one way or the other. In other words, whether the victims' families' lawyers are bringing out information that may not be in the foundational documents, that may contradict some stuff that's in the foundational documents, that sort of thing, challenging those facts, challenging the RCMP account of the situation. So something to watch. Interesting news that came out this week. Thanks to Paul Palango and Jordan Bonaparte for bringing this to us, and they encourage them to keep up the good work. And thank you for listening. Thank you for watching, and we'll see you again soon.